Hi, Liz and I would like to welcome you to today's seminar, Emerging Issues and Legislation in Maine Workers' Compensation. We have a list of emerging issues that we will review with you, and then we'll speak briefly about a number of bills that have been proposed that could have a vast impact on workers' compensation in Maine. We'll wrap up our presentation with a very brief overview of emerging issues from around the country, in case anyone in our audience has locations out of state. Webinar attendees should note that your phones, headsets, and microphones have been muted to avoid background noise interference. Please feel free to send questions to the host as they arise using the Q&A function. We do have a full program, but we will do our best to answer all of your questions at the conclusion of the webinar as time allows. Before we get started, let's introduce ourselves. My name is Elizabeth Connellan Smith, and many of you know that I'm of counsel at Verrill Dana in the Labor and Employment Law Department. I've been practicing workers' compensation defense work for about 25 years now, but also practice all other aspects of general employment law, including advising clients on ADA and FMLA issues, I-9 compliance, OSHA, and anything else related to having employees. I'm on the board of directors of the National Workers' Compensation Defense Network, and I'm also 2 years into my 3-year appointment as defense co-chair of the American Bar Association Labor and Employment Law Workers' Compensation Standing Committee.
Good afternoon, everyone. My name is Liz Johnston. I'm an associate at Verrill Dana, also in the Labor and Employment Department. My practice focuses on workers' compensation defense as well as other aspects of employment law, including discrimination claims on the state and federal levels and compliance. With that, Beth will get us started looking at some trends that we're seeing in workers' compensation today.
First, Healthcare 2020. Given the recent elections, it seems virtually impossible to repeal the ACA, although a Texas judge has ruled it unconstitutional. So the national trend opposing the ACA should inform decisions on healthcare coverage and how it may impact workers' compensation claims. Additionally, there is a federal push to drive down the cost of prescription drugs, which have been consistently rising over the last few years. An emerging model of note is the Accountable Care Organization, in which physicians are rewarded for desirable outcomes as opposed to the standard value cost of care reward system. This outcome-based model could be really useful in the workers' compensation context, where the opposite has been the trend in Maine. In the present workers' compensation system in Maine, I have experience with a number of providers who operate repeatedly on a single body part at an alarmingly high rate with predictably poor outcomes. Historically, reimbursement rates under the workers' compensation fee schedule have been higher than those available under regular health insurance, and at times, I'm convinced that has been a driver of the high medical expenses and poor outcomes we see in litigated cases. Outcome-based reimbursement would reverse that trend and possibly push the less qualified practitioners to a different business model. Next, some large employers are beginning to offer on-site health care to the general population as opposed to simply maintaining a health care center for employees, an interesting trend to explore in the workers' compensation context. I could foresee increased insurance coverage risk, however, as the employer would have to foresee potential injury claims from non-employees who might suffer an injury while attending a medical appointment. But the increased ease of seeking treatment as part of a regular workday or even just as part of a shopping trip speaks to Gen X, who prefer swift and easy problem resolution. Some of you may also be familiar with Becky Curtis, who was ahead of the trend when she started her telephonic chronic pain business, Take Courage Coaching. Becky offers trained coaches who do regular telephonic group and individual coaching of injured workers suffering from chronic pain to help them find their new normal and regain whatever they can of their regular life. Becky herself is a workers' compensation survivor, having suffered a partial quadriplegia in a work-related auto accident. She developed a CELI, which is a cyst on her spinal cord that is not operable, and to cope, she developed her own pain management system. Then, she turned that into a successful business. Chronic pain and its successful treatment remains an issue in Maine, with really only one medical practice offering a comprehensive, holistic program. Additionally, we currently do not have an inpatient program, and for the most serious cases, inpatient treatment may be required to have any hope of success. Another branch of this healthcare trend is the focus on social determinants of health. Vulnerable communities are at the greatest risk of poor outcomes, such as rural-based employees, socially isolated employees, and our aging population. Maine is the oldest state in the union, and frankly, obesity continues to be a chronic health issue here. Some trending new initiatives include coordinating healthy meal delivery post-surgery, home visits to assess safety issues and make recommendations, and offering iPads and apps to allow for more connectivity and resources.
Another trending issue that we're seeing comes with newly elected officials across the country. 8 states, Alaska, Illinois, Kansas, Maine, Michigan, Nevada, New Mexico, and Wisconsin, have elected governors from the opposite party from the party that held the seat prior to the election. With these new governors, we often get new regulators and administrative law judges or other personnel critical to the functioning of state workers' compensation systems. In addition to the new governors, 6 states, Colorado, Illinois, Maine, Nevada, New Mexico, and New York, now also have the electoral trifecta, a Democratic governor, Democratic House, and Democratic Senate. These shifts will likely be reflected in legislation that is put forward, and we are already seeing these trends come out. Nationally, there are over 100 bills impacting workers' compensation that have already been proposed. These trends are being seen in Maine already as well. Over a dozen bills have been advanced that would have a significant impact on a number of workers' compensation issues. And we'll discuss these, the pending legislation, a little bit later in our presentation. Maine also has a new executive director of the Workers' Compensation Board, and that's John Rohde. The executive director serves at the will of the governor in Maine. Rohde has spent his entire career with the Workers' Compensation Board, serving as the general counsel. In that role, his job was to draft and review rulemaking, advise on legislation, and advocate the position of the board, if necessary, at the legislature and before the business and labor communities. For much of Rohde's career as general counsel, or until about 2010, the executive director was Paul Dion, a staunch pro-labor Democrat. We expect that Rohde will be more labor-friendly than the latest executive director, Paul Signolfi, which may mean that the business community may not fare as well at the board level.
The next trend we're seeing is the biopsychosocial model to pain management. That trend includes treating pain and injury holistically, such as treating pre-existing or underlying mental health diagnoses like anxiety to assist in reducing the experience of pain. As I mentioned above, Take Courage Coaching is a business that's expanding across the country, offering telephonic coaching to chronic pain sufferers. Another trend in claims administration is identifying a pain philosophy that implements a pain assessment tool early in the claim, outlines care pathways clearly to injured employees, creates a patient-centered care continuum, identifies skilled consultants to engage early in the process, and seeks feedback from stakeholders at regular intervals, including from the injured worker. This holistic approach is being seen in other areas of workers' compensation, including claims adjustment, litigation management, and certainly is a tool that an employer should consider implementing in the workplace.
The next trend we're seeing relates to permanent impairment and the political effect on how we assess that. As many of you know, the AMA guides to the evaluation of permanent impairment are used to assess an employee's level of permanent impairment caused by a work injury. However, there are significant differences between the specific editions of the AMA guides. The latest 6th edition was hailed by experts because it recognizes that the purpose of medical treatment was to restore prior function, not just to assign a physical diagnosis. The objective of that 6th edition was to establish the measurable impairment in an employee's function rather than simply assigning PI ratings based on the physical diagnosis of a condition. However, because the use of the 6th edition often yielded lower permanent impairment ratings, the claimant's bar has objected to its use. In fact, a Kansas court has already rejected the legislature's adoption of the 6th edition in a case where the 6th edition yielded a PI rating that was 19 points less than the PI rating under the 4th edition standards. Attorneys in other states will likely also bring litigation to try to revert to prior editions that are more financially favorable to claimants. In Maine, the 4th edition is still the version of the guides that is generally accepted by the board. I'd be surprised if going forward our local board didn't simply refuse to accept the 6th edition for determining permanent impairment.
Next trend is the economy's impact on workers' compensation. More workers are in the workforce due to record low unemployment rates. This means companies are hiring workers who are in poor condition physically, or they're hiring non-ideal candidates due to the need for staff. Certainly in Maine, I'm hearing anecdotally about hiring issues, where I've even had clients rehire former employees who were terminated for poor attitude or poor attendance, only to find that the problems that led to the initial termination continue. Cynically, the cases I see in litigation often involve an employee who was on the brink of termination for repeated violation of company policy. When that employee suffers an unwitnessed injury, the claim comes under scrutiny at a higher rate than a claim of an unwitnessed injury for a high-performing employee, hence higher cost. A subset of the economy's impact is categorized as talent training and development. Because the economy is on fire, turnover is higher than ever, and employers compete to offer benefit packages and other incentives to attract and retain employees. Adding to this is the fact that some traditional jobs are no longer attracting as many qualified applicants. For example, in years past, a bright young person who did not have the means to continue education post-high school might seek out a position as a secretary or in some other office-type position that didn't require a college degree. Such a position offered security and the opportunity for growth along with good benefits and wages. Not only has the population of high school graduates who are not continuing their education in some manner drastically dropped, but with the advent of online education, that employee really no longer exists. As a result, employers are struggling to find qualified candidates willing to perform the sometimes boring or mundane menial work while patiently waiting to advance toward management. Additionally, while not a new issue, seniority does not necessarily equate with managerial temperament. That is where training that can be accessed anytime, from anywhere, becomes a useful tool. Online training enables an employer to coach employees to develop skills that will make them more productive and more successful. And wise employers should keep wage and hour considerations in mind, but utilizing online or other non-traditional training can add to an employee's success and an employer's success in both attracting and retaining those qualified employees. Keep in mind, please, that the generalization is that Gen Xers and millennials are not like baby boomers. They have no intention of holding one job with one company for their whole work life. Generally speaking, Gen Xers and millennials are much more inclined to move from position to position, seeking fulfillment and balance in home, family, community, and passion engagement. Gearing your recruitment and retention policies toward a more holistic and balanced work-life passion goal is much more likely to result in not only higher morale, but also fewer overuse, mental health, or other work-related injuries.
Another trending issue relates to what we refer to as mega claims. So when we say mega claims, we're referring to those claims with exposure in excess of $5 million or around there. The number of these claims is increasing nationally, and that's due to a series of factors. One of these is an increase in the number of work-related auto accidents. Another factor is that there are increasing overall advances in medical treatment. And although it seems at first glance that advances in medical treatment might reduce treatment costs, the advances also mean that employees have a much greater chance of surviving what would otherwise be a catastrophic accident or injury. And because they survive, they end up needing lifelong treatment thereafter. Likewise, medical device innovations are leading to greater life expectancy, which means, again, more treatment and for longer. A Massachusetts company, for example, has created an exoskeleton that, when worn by people who are paraplegic, enables them to stand and walk again. As you can imagine, restoring the ability to stand and walk greatly improves all aspects of an injured worker's life, leading, again, to a greater life expectancy. Another reason for the increase in mega claims is increasing medical costs and litigation costs. In jurisdictions with a more liberal application of workers' compensation laws, the cases going to litigation are often much more complex, either medically or factually, and that leads to greater costs to both prove and defend against the claims.
The next emerging trend is the impaired workforce. That trend was previously driven in Maine by opioids, but now that many states, including Maine, have legislated the prescription of opioid medication, the new culprit is legal, medical, or recreational marijuana. 10 states in the District of Columbia have legalized recreational marijuana, including Michigan, Alaska, California, Colorado, Maine, Massachusetts, Nevada, Oregon, Vermont, and Washington. And Canada just legalized recreational marijuana in October of 2018. On top of that, 33 states have legalized medical marijuana. And of those states, 8 are considering whether or not to legalize recreational marijuana. Since marijuana remains a Schedule I drug, science hasn't caught up with the push to legitimize marijuana or its compounds as a medicine. An employer's ability to restrict or discipline employees who are or appear to be impaired on the job depends on the language of the state's implementing statutes, since a wave of legislation to legitify marijuana has overtaken the country. Now, furthermore, there's not yet a consensus on what impairment means due to the manner in which THC, the intoxicating compound in marijuana, is absorbed by the body. It is not as absorbed necessarily by the bloodstream. It's actually absorbed by the fat. So it can show up long after the actual use. Therefore, THC levels are most accurately measured by a blood test, which is a fairly invasive test. The provision of the Act that includes defense to any work-related injury if it is caused by intoxication in Maine is likely to be challenged now that marijuana is legal both medically and recreational. So stay tuned for that seminal case that will explore the intoxication measurement and the science around it and make sure you're not the employer involved.
The next thing I want to talk about is unconscious bias and cultural differences. So unconscious bias is one of the latest theories relevant to both management and team building, and that's much like Six Sigma and total quality were in their time. If you're not familiar with the term unconscious bias, it refers to positive or negative beliefs about individuals or groups that are triggered automatically and exist on an unconscious level. In essence, all of us have bias that we may not be aware of, and it's developed over years of navigating the world through our perspective. Because these biases live below the surface, though, it's less obvious when we are acting on them, and so awareness of their existence becomes key. It's therefore important as an employer to educate yourself and your employees on principles of unconscious bias and design trainings that promote inclusiveness and understanding throughout the workforce. Stakeholders in the workers' compensation arena come to the work of preventing and managing work-related injuries with those unconscious biases in mind. Being aware of unconscious biases could, for example, mitigate potential differences in the claims process or outcomes for certain individuals over others. In addition, recovery outcomes can be significantly improved with a culture of inclusiveness, especially as it relates to individuals who come into the country from another. Using Maine as an example, the state is becoming more diverse, including with many new Americans from Sudan, Burundi, and the Congo, and other countries. When an employee from one of these countries of origin suffers a work-related injury, he or she may not know how to navigate the system or even trust the system to assist with their recovery. Medical treatment may have been different in their home country, and there may also be social differences to be aware of as well. Although these are both huge topics, simply extending the effort to recognize unconscious bias and become culturally literate in the differences and possible barriers to recovery could prevent a small injury from becoming an expensive loss to the workforce and labor market.
The next emerging trend is workplace violence. While incidents of workplace violence have been rare in Maine, that is not the trend nationally. Healthcare workers are the most likely to suffer some type of workplace violence, and given Maine's aging population, the possibility of an assault by an elderly Alzheimer or dementia care resident is a very real possibility, especially as our life expectancy increases due to better access to quality health care. Special education workers are the next most likely to suffer some type of workplace assault, followed by regular school workers and finally retail workers. Maine employers occupy all of these areas of the economy and should be aware of and have policies to address attacks or aggression in the workplace. Additionally, the present political climate remains charged with strong and vocal opinions the norm. Since employers cannot prohibit political speech in the workplace, implementing a policy of inclusiveness, respect, and tolerance is the best way to prevent distracting and possibly costly altercations between employees or vendors.
Our next trend relates to the gig and sharing economies. It isn't news that the gig and sharing economies are on the rise nationally. In fact, the Department of Labor just relaxed the definition of what constitutes an independent contractor, which applies to a lot of employees or persons working for these organizations. Maine's definition, however, remains fairly strict for workers' compensation purposes. In any case, platforms like Uber, Lyft, Airbnb, TaskRabbit, these have all made their way into Maine and international workforces, providing what they call, or what many people call, side hustles for employees in addition to their day jobs. Although Maine has not directly addressed the issue of whether an Uber or a Lyft driver is an employee or an independent contractor of that organization, if the person involved is also working a day job, perhaps for you, you should be aware of any side hustles that the employee is participating in on the side and that potential to impact the employee's productivity as well as increase risk of injury occurring during that side hustle. Causation is a key factor in determining the compensability of an injury, so it's important to be aware of those potential hurdles that might arise when an employee is wanting to establish an injury as arising out of his or her regular employment, when the side hustle could actually have contributed to the injury or cause it to continue to worsen if they're still participating in that other job.
And our final trend for today relates to natural disasters. This winter and spring brought violent and often devastating storms to much of the country, including, I don't know if you all remember, but we just had a snowstorm in April. The trend to be aware of here is disaster planning and response planning. It's critical to have a means of communicating with employees that does not rely on resources that might be rendered unavailable during a storm. You certainly do not want to have your employees racing into their scheduled shift when in fact the storm's been so bad that you had to shut down the facility, because that could potentially give rise to a claim of a work-related injury. Further, business disruption insurance might be a good investment, and planning for employees who work remotely or who travel for work to avoid unnecessary risk should also be part of any disaster and response plan. With Maine's new Democratic governor and legislature, numerous bills have been proposed that could have an enormous impact on the workers' compensation system in Maine, as we mentioned earlier. These bills are, for the most part, very employee-friendly, and so it's important to be aware of changes that could take effect in the coming months and years. We're going to now summarize a few of the most significant bills proposed this term.
The first bill that we want to talk about is LD 600, which is an act to achieve mental health parity in workers' compensation. So the proposal of this legislation reflects an increasing focus on mental health, which has been trending nationally over the past several years. So this bill in particular aims to change the standard of proof necessary to establish a mental stress injury as work-related. When a worker claims a mental stress injury, he or she must establish two things. One, that the work stress was extraordinary and unusual in comparison to the pressures and tensions experienced by the average employee. And two, that the work stress, and not some other source of stress, was the predominant cause of the injury. Under the current Section 201, the employee must prove this by what we call clear and convincing evidence. It's a relatively high standard, and it requires that the fact that the employee is seeking to prove be highly and substantially more likely to be true than untrue. However, the proposed law lowers the required proof to what we call preponderance of the evidence, which means that it's just more likely true than untrue. What this means is that if the employee can prove their case by 51 to 49%, If the evidence is 51% in favor of the employee, then the administrative law judge could find in his or her favor on establishing a mental stress injury. The other significant change that LD 600 proposes is to establish that a work-related injury that aggravates, accelerates, or combines with a pre-existing mental condition may result in a compensable disability. Currently, only aggravations of physical injuries can result in compensable injuries, and there is already a low bar for establishing aggravations for physical injuries, so this broadened legislation could really open that exposure up to a new host of claims, especially considering that work-related injuries can take a strong mental toll on employees suffering from them. In addition, I anticipate that these claims might take longer to reach resolution, given the small number of mental health professionals that perform Section 207 exams or are on the Section 312 roster.
The next bill we want to draw your attention to is LD 758, an act to clarify work search requirements for workers' compensation. It essentially flips the burden of proving an employee's ability or inability to find suitable employment from the employee back to the employer. Currently, an injured worker who is partially incapacitated due to a workplace injury medically may be eligible for 100% partial incapacity benefits if that worker can demonstrate that the lack of employment is due to the injury or the residual effects of the injury, and the worker has not been able to find work within the work restrictions imposed due to the work injury. This generally requires that the employee perform what's known as a work search. Work search means what it sounds like, a search for work at various open advertised jobs. The accuracy of that search is then analyzed under the factors established in the law court's Monahan versus Jordan Meats case. Once the employee has met that burden of proof, the employer can prevail by challenging the work search evidence with other information, such as a labor market survey showing that available employment is there in the labor market that would be suitable for the employee, taking into account the residual work restrictions, the education, training, and past employment. The proposed bill does away with the work search rule by creating a rebuttable presumption that if the employee is unable to obtain suitable employment at the original employer, then that employee is entitled to 100% partial benefits. It then becomes the employer's responsibility to rebut the presumption by providing evidence that suitable work exists elsewhere in the community within the employee's restrictions. However, the employee can still overcome that evidence by demonstrating an inability to secure such employment despite reasonable efforts. The effects of this legislative change is not only obliterating the judicial work search rule and balance of proof between the employer and employee, but additionally, there'll be intense pressure on the employer to fashion some type of accommodated work to avoid the initial presumption that the employee is entitled to 100% partial incapacity benefits. Even under the current framework, it is extremely difficult to prove that the employee can't find suitable work. Suitable work, as the board historically has accepted an employee's testimony that they looked for work, they produce a list with a lot of employers and open positions on it, and they say, I haven't been hired. Even with follow-up testimony showing that there are open available positions, often the employee is awarded 100% partial benefits. With the proposed legislation, claims will become much more expensive, as there will no longer be any need to show medical restriction combined with the employee's unique psychosocial characteristics are impairing the employee's return to work.
Another controversial bill proposed is LD 947, which is an act to extend the notice period in Maine workers' compensation. This bill aims to increase the notice period from 30 days to 180 days for injuries occurring on or after January 1, 2020, meaning that employees could wait 6 months before letting the employer know that they suffered a work injury and still be protected under the act. Shenna Bellows, the proponent of the bill, argues that many workers are prevented from getting benefits because what she has called, quote, arbitrary and unfair deadline, end quote. Proponents also argue that the 30-day benchmark is short compared to the 180-day period to bring civil claims, 300-day period to bring Maine Human Rights Act claims, and 3-year period to bring medical malpractice claims. However, the 180-day notice period could cause a host of problems. It could dissuade workers from getting treatment for an injury until months afterward, causing the injury to worsen even if swift treatment could have been effective. Also, if there is an unsafe working condition that caused the injury, a delayed report might prevent the employer from becoming aware of a situation that could cause harm to others. The extended time frame could also lead to more difficulty establishing or refuting causation of the injury due to a long lapse of time between the incident and report or treatment. Also, it's worth noting that most states cap the notice period at as long as 90 days, and this would make Maine a significant outlier in compared to other states' notice periods.
Next, we have LD 1204, an act to eliminate the cap on weekly benefits in workers' compensation cases, presented by Democratic Representative Sylvester of Portland. This bill seeks to eliminate the cap on maximum weekly incapacity benefits, which is currently based on a percentage of the state average weekly wage as of the date of injury. If the bill becomes law, incapacity benefits for most injuries would be calculated at 2/3 of the employee's average weekly wage, regardless of their income level. This would make Maine the first and only state in the U.S. to eliminate a cap on benefits. Parenthetically, Alabama has been looked at because their maximum rate is so low, it's been found to be unconstitutional in at least one case. The problems here are obvious, as the cost to employers and insurers could be astronomical for a high-earning employee. Although employees should be entitled to benefits after suffering a bona fide work injury, the workers' compensation system is supposed to be balanced to incentivize a return to work while supporting the employee transitioning back into work. It's not intended to be a limitless income replacement tool. This proposal would disincentivize returning to work, as obviously you would have a substantial untaxed benefit payment while out of work.
There are also a few bills on the table regarding injured employees who have retired. First, LD 1203, an act to clarify the retirement presumption. This bill aims to lower the burden of proof on employees to continue receiving workers' compensation benefits into retirement. Currently, Section 223 establishes what is commonly known as the retirement presumption. The presumption provides that when an individual is receiving workers' compensation benefits and they retire and begin receiving retirement benefits, the employee is presumed that the employee has withdrawn from the workforce due to retirement and is thus no longer eligible for benefits based on loss of earnings or loss of earning capacity. The employee can rebut this presumption, though, by presenting evidence that he or she is unable to perform suitable work in whole or in part because of the work-related disability. Under the language in the proposed bill, the employee would need to provide even less evidence to continue collecting workers' compensation benefits. Essentially, the employee would only need to establish that the retirement was due, at least in part, to the work-related disability, to draw language from the statute, or the bill. Elizabeth Brogan, who's the Executive Director of the Workers' Compensation Coordinating Council, submitted testimony opposing the bill, and she noted that it would, quote, gut the retirement presumption by shifting focus away from work capacity, which can be determined by medical evidence. Indeed, the proposed language is unclear as to what exactly this would look like or what exactly the employee would need to show to be entitled to presumption, but it certainly opens the door for employees to more easily remain on workers' compensation benefits even after retiring for reasons wholly unrelated to any injury limitation.
Further compounding the retirement issue is LD 1205, an act to allow full retirement benefits under the Maine Workers' Compensation Act of 1992. This bill would eliminate the existing offset of 50% of the Social Security retirement, or SSI, benefit when the employee accesses SSI, and it completely eliminates the offset of any other employer-paid portion of a pension benefit received by the injured employee. The bill would also seriously disadvantage employers and insurers and provide what is essentially a double recovery, or at least 1.5 times recovery to an employee. Workers' compensation benefits are designed to replace wages lost due to a work injury, while retirement benefits are designed to replace wages lost due to retirement. As I said, without the offset, the employee can receive both workers' compensation benefits and full SSI benefits. In addition, the legislation would prohibit the employer from recouping overpayments of benefits from employees. This part of the provision is in direct response to the Maine Supreme Judicial Court's opinion in Urrutia versus Interstate Brands International, decided last year, which suggested that an employer could take a holiday on benefit payments when it had been prevented from taking an offset by the employee's failure to disclose receipt of Social Security insurance benefits. In any case, without any offset, the latter provision becomes a moot point.
Another bill that could significantly increase the cost of claims is LD 1253, an act to fairly compensate for fatal accidents under the Maine Workers' Compensation Act of 1992. This bill proposes eliminating the 500-week, or what's essentially a 10-year cap on benefits when an employee dies due to a work-related injury. Although this would only affect likely a limited number of claims, the claims that do involve the death of an employee would become drastically more costly, as benefits could be owed for 20, 30, or even 40 years in some circumstances to the surviving family.
There are a few other bills that we'd like to make you aware of as well. One is LD 601, an act to create fairness by reinstituting cost of living adjustment for workers' compensation benefits, which aims to reestablish the cost of living adjustment that was in effect prior to the 1992 revisions. It would increase or decrease an employee's weekly compensation on an annual basis based on the state average weekly wage. Most often, as you know, it would increase the benefit. The cost of living adjustment was one of the driving factors behind the reforms of 1992, since workers' compensation is known as a long-tail coverage, meaning that the claims can last for years. While there is some unfairness in the current system that I need to acknowledge, which sets the compensation rate as of date of the accident without taking into account any type of inflation, the grand bargain, as it is known, is supposed to be just that, a trade-off, seeking to devise a system that compensates an injured worker swiftly, but also incentivizes both the employee and the employer to work together towards a swift return to work. In my opinion, this bill would fail in that role with respect to the employee.
So next, there's LD 809, and this is an act to expand and clarify the disqualification from workers' compensation benefits of an employee who's injured while under the influence of drugs or alcohol. So what this proposed bill does is essentially just add an extra layer of protection to employers by providing that if an employee is under the influence of marijuana, it may preclude the worker from getting benefits for an injury that occurred while under the influence. Honestly, it's really an unnecessary bill since intoxication is not strictly defined under the current act, and it can be and has been broadly construed to include intoxication from drug use.
Finally, we have LD 1501, redefining occupational disease claims. This bill is an attempt to do an end run around the current Section 2014, which addresses the aggravation, acceleration, or combination of some work activity with a pre-existing condition so as to render the non-occupational pre-existing condition a work-related injury. By adding a new definition of a personal injury as any condition or disease contributed to by an employee's occupational cumulative trauma or exposure, tucked into the existing but rarely used occupational disease portion of our Workers' Compensation Act, labor clearly is attempting to address the growing phenomenon of non-occupational degenerative processes being brought within the protections of the Act, either to avoid expensive health insurance copays or to guarantee income beyond what might be available under short-term disability. Again, if successful, this could have a drastic impact on costs to employers. There are several other bills pending that have the capacity to negatively influence our current workers' compensation system in Maine, but the ones that we have just described are the most critical in our opinion presently. If you or your business has an opinion on these proposed bills, please reach out to Peter Gore at the Maine Chamber of Commerce, as he is actively working on behalf of the business community and does have the ear of the Labor Committee. And now, just a bit on our national updates. There have been some interesting developments across the country, and due to my membership in the National Workers' Compensation Defense Network, as well as my new national role with the ABA, I've had a unique opportunity to see what's happening in other jurisdictions in advance of any of these getting to Maine. First, in California, there has been some action regarding the apportionment of disability due to genetics as opposed to a work-related injury. This is a bit surprising to me, since in general, employment laws in California tend to be very employee favorable, and this proposal actually could potentially provide a bit of a break to an employer in a situation where the employee has some type of genetic condition that exacerbates either the injury or the recovery process. An example that comes to mind is that diabetes could sometimes lengthens the time of recovery that would have been anticipated following a type of surgery. The Court of Appeals in the 3rd District in California issued an opinion holding that apportionment to genetics is permissible in some cases, pursuant to the opinion of a qualified medical expert. This, of course, will raise a host of potential proof and apportionment issues, and the legislation is currently pending to determine whether that case will stand or not. Next, Indiana is dealing with a new narcotics statute that is designed to address opioid issues that are affecting that state as well as many others across the country. The new legislation will create changes in authorization and procedures for parties to a workers' compensation claim. So it's a good reminder to be aware that as narcotics laws are changing, employers need to be prepared to react accordingly.
In Kansas, we talked a little bit about this earlier regarding permanent impairment standards, but a Kansas court has rejected the use of the 6th edition of the AMA guides. So just like those changes in narcotics laws that are going to be springing up across the country, we should be prepared for other states to follow Kansas in that decision, or even legislatures to put forth bills to that effect. New Jersey has also had an interesting development recently. The New Jersey Assembly recently passed and the governor signed into law what was Bill 2145, which made a significant change in the workers' compensation statute by removing the incentive for employers to make voluntary offers of permanent and partial disability without having to pay a counsel fee on the amount offered. The original law, which was known as the bona fide offer rule, has been unchanged since the 1920s. That law provided that any offer of permanent partial disability made to an injured worker within 26 weeks of the last active medical treatment or return to work date was not feeable for the attorney. Neither the petitioner nor the employer would pay a fee on the amount of the valid voluntary offer. Under the original law, counsel fees were awarded to petitioners' attorneys, and they were based solely on the amounts paid to the injured workers in excess of the amount of a voluntary offer of payment. Essentially, this is mutually beneficial for the employee and the employer-insurer. The injured workers benefited by not having to pay the counsel fee on voluntary offers that is customarily prescribed to the petitioner, and by receiving payments while their case was still pending in the division. Those funds might help tide the worker over while the ultimate settlement was negotiated. And the benefit to employers, of course, in making these payments was avoiding paying a counsel fee on the amount that was offered. Under the new law, however, a petitioner's attorney will be entitled to a fee on all amounts received by the injured worker if the attorney can prove an established attorney-client relationship pursuant to a written agreement prior to the date of the voluntary offers. In other words, the claimant's attorney gets a fee on all payments of permanent disability benefits made after the date the written engagement letter was made. Finally, we're seeing New Hampshire go along with the trend of addressing compensability of medical marijuana in the workers' compensation context. In a ruling last month, the court essentially held that the legislature did not create an obligation to pay for medical marijuana, but it also did not preclude reimbursement of medical marijuana. So it's a little bit different than other states that have recently addressed the issue, such as Maine, making an affirmative decision on whether it's reimbursable or not. The New Hampshire court actually avoided the issue on whether payment is precluded by federal law and remanded the issue back to the Workers' Compensation Appeals Board to further explore that issue. So currently, the reimbursement of medical marijuana remains optional for employers.
We're going to open up now for some questions. I see we have one question that we can address here. Bringing that up. Just bear with me a minute. Let me bring the question up. The question is, do you see any trends regarding the employer's obligation to offer light-duty work? Great question. And honestly, I do see national trends. There's been an increased dialogue about what constitutes bona fide transitional duty work. And I anticipate that dialogue will continue. There's been a significant amount of pushback in other jurisdictions with a lot of analysis as to whether the accommodated work is real work or not. In Maine, as you know, we don't have any obligation to make work, in other words, to create a made-up job, but most employers do make an effort to create transitional duty work. Given the bills that have been proposed, I would anticipate a bigger push than already exists by our employers to try to return employees who are injured to accommodated work, particularly should that bill that proposed that the employee is presumed to be 100% incapacitated if they can't return to work with the employer. Assuming that passes, that will have a huge impact on offers of transitional duty work or light duty work in Maine. All right. I'm going to invite anybody who wants to reach out to Liz or me offline if you would like, if you have questions that you're not ready to post to the group. We're both always happy to address those questions. And I'm going to thank you now for joining us in today's webinar. The presentation recording and a copy of the slides will be made available following the program. Again, please don't hesitate to contact either me or Liz with any further questions. And we also encourage you to check out our blog, Taking Care of HR Business, accessed at hrlawupdate, all one word, .com, for more updates in workers' compensation and labor and employment law. We also post updates on the labor and employment section of the Verrill Dana website. Thank you very much.